when a brand has expanded into other areas or different or new goods and services, you have to think about additional trademark applications to cover those expanded goods and service offerings. And that's what Taylor Swift has done and her legal team has done. They think way outside the box. Hey there, I'm Paige Griffith, your host and an attorney for small business owners. I help online businesses and creatives get legally legit in no time. This podcast is all about the legal and the Paige behind it. I'll break down and simplify legal talk while providing practical business guidance every step of the way. And after over a decade in the entrepreneur space and becoming a mother, I'll also be sprinkling in tips for running a business and giving you a glimpse behind the scenes of what life's really like. As a gentle reminder and disclaimer, I am an attorney, but I am not your attorney. So be sure to seek legal counsel for personalized advice. Welcome to the Legal Paige podcast. Recently, Taylor Swift made headlines again, but this time it wasn't for a new song or a tour announcement, although that could happen after I record this episode. But Miss Swift filed for a trademark for, quote, female rage, the musical. And as a trademark attorney, I just chuckled inside because this was a term that she coined to describe the newly added Tortured Poets Department portion of her Eras tour. And a lot of people were saying, female rage, but then she coined it and deemed it female rage, the musical. So she is someone we can learn from regarding trademark and intellectual property ownership. Tay is not just a musical sensation, but I have always thought of her as one of the savviest businesswomen that I have never had the pleasure of meeting, but feel like I know very well because I am a true Swiftie at heart. She has successfully built this brand that extends so far beyond her music. And over the years, she has trademarked, honestly, as many phrases and song titles as possible, including This Sick Beat and Nice to Meet You, Where You Been, as well as her name, Taylor Swift, and song titles that we all know and love, like Shake It Off, We Are Never Ever Getting Back Together. But why? Why does Taylor do this? Why is trademark protection so important, especially in the competitive music industry and in the business industry as a whole? By trademarking phrases and titles, Taylor ensures that not only can she use those phrases and titles and business names in association with her products and services, but it helps her maintain control over her brand and image and prevents others from profiting off of her hard work, her creativity, and her brand that is so extensive now. So in this episode, I really want to talk about the significance of trademark protection, how it can really be a powerful tool for artists and for you as a business owner. We will discuss, of course, what trademarks are, the benefits that they offer, and then how you can leverage intellectual property protection and trademark protection for your brand and safeguard your business just like Taylor Swift does. So whether you are an artist, a business owner, or you're just curious about the legal side of trademarking brand names and phrases, this one is going to be a good one for you. Let's start with how many trademarks Taylor Swift has. She has about 50 trademarks and owns over 200 federal trademark registrations through the United States Patent and Trademark Office. She started using trademarks in 2001, started registering them in about 2008. She started using trademarks as early as 2001, started registering them and filing for trademark applications in 2007 and in 2008. Since then, she has filed over 350 trademark applications. She does not own all of them. I think it's around 200, like I mentioned now. It's extensive. It's hard to, if you just go in and type into the trademark search system, which you can find on the USPTO website, you type in Taylor Swift and so much pops up. And if you scroll, you're just going to be amazed. Let me just go through a list of trademarks that she has. Her name, so Taylor Swift, her initials, TS. Her fan club, so Swifties, Swiftie, Taylor Nation. The names of her tours, such as the 1989 World Tour, the Eras Tour. Names of her albums, so Fearless, 1989, Red, Tortured Poets Department. Song titles, of course, Shake It Off, one of the most famous song names, but also brand names as a whole for her. Select song lyrics within the songs themselves. Player's Gonna Play, Blank Space, Look What You Made Me Do. Of course, Reputation as well. She's also trademarked Swiftmas, Meredith and Olivia Swift, her cats, Daymoji. It's insane. It's insane what she has done and what her legal team does as well. And while I think that this is very, very smart of her to do, it's also really important to think about alternative legal views surrounding Swift's extensive trademark portfolio, because there is a fine line between protecting your assets and also kind of being seen as doing too much. Not necessarily being seen as a bully, but there's no indication that Taylor has like crossed the bully line. But the conversation is worth having, because if you own so many trademarks, then you have to make sure that no one is diluting those trademarks. So you have extensive legal help in monitoring those trademarks. But then you have to sue people up the wazoo when they have infringed on your trademarks and send cease and desist. So yeah, you want to protect as much as possible with your business. And why shouldn't she be able to protect whatever assets she has, right? Why not make as much money as she possibly can? She's a business owner and she can. And I think it's interesting for male attorneys in particular to look at this subject because they see it from a different light. Like, is there too much intellectual property protection? I mean, she's the biggest superstar on the planet today. By no means is guaranteed to be the case indefinitely. But the entertainment business is honestly a fickle one. And the history of the entertainment business is littered with people who were once a star and are no longer a star. I don't think that's going to be Taylor Swift's case at all, especially because I'm a Swiftie. She has maintained in an amazing career. It's going to be long living. The longevity is going to be there. And a lot of people maintain long careers, but without their reputations intact. And while she is maintaining her brand reputation as much as she can, the flip side of this is that level of control that she seeks over her brand could become impractical, right? Endless lawsuits might not be wise from a logistical perspective. Remember 2 years ago when Beyonce tried to like scrub the internet of all of those Super Bowl halftime pics that made her look like She-Hulk? Well, that didn't go as planned, because once something's out there on the internet, it's there forever. So building goodwill in the public eye can sometimes be a more effective strategy. And from every piece of fan-made merch that Swift takes down, 7 more could rise up, right? Like, she can't protect everything. She can protect as much as she possibly can. But the impracticality of that, time is not on her side here, and legal, enforcement isn't on her side here. So fortunately for Taylor and all of the Swifties, like, her relationship with her fans remains strong. They know that she owns all of these trademarks. And so as long as her legal team and her keep her eye on the ball, she will have a lot of leeway to go after anyone she wants that is infringing on her trademarks while still keeping her brand intact. Now, what does this mean for you? Why am I telling you that Taylor Swift is truly the mastermind, quote unquote, of IP strategy? She, of course, has a bigger brand protection budget than most. But you, as a brand owner, you can still learn a lot from her. And I'm going to go through just a few things right now that you can do and think about if you're a business owner and you have a logo, you have a brand name that you've worked really hard on that's unique. Maybe you have sub-brand names and taglines like we talked about with Taylor and what she owns, like the extensive portfolio of trademarks that she owns. I'm not saying go out and trademark 50 different things. Maybe just if you don't own a federal trademark or a state trademark, look into maybe owning one, your business name, start there. And then other sub-brand names and taglines that you use constantly. So first, I want you to consider kind of creating potentially a business if you don't have an LLC already, or an IP holding company or a separate entity to own any of your IP. And so Taylor Swift does this, something you should do as well. Also, consider filing trademark applications early, even if they are not used in commerce. You can file what's called an intent to use application, but it's all about the date that the application was filed. So it's really like, it's first in use, first in right, but it's also like a race to register in the United States. So you want to avoid any third parties capitalizing on your brand or your sub-brand names or your taglines by filing your trademark application early. And she does that right away, as we saw with Female Rage, the musical. Before it got out there and as it was like starting to gain traction online, she was like, boom, file a trademark. Take that same approach for your business if you can and if your budget allows for it. Next, I just want you to consider the goods and services that are relevant to your business or may become relevant, because that's really important to think to future forecast. What is going to happen to my business? When you are preparing a trademark application, you can file an in-use application or an intent to use. So if something is going to maybe come down the pipeline here in the next 12, 24, 36 months, and you really like that business name or that sub-brand name or tagline, remember a trademark is all about association and connection to your brand and services or products that you offer. It's not a copyright registration. It's all about brand association. So if you are thinking about anything that could occur, that this might be a good time to talk to a trademark attorney and or to think about trademark registration yourself. Next, when a brand has expanded into other areas or different or new goods and services, you have to think about additional trademark applications to cover those expanded goods and service offerings. And that's what Taylor Swift has done and her legal team has done. They think way outside the box. Female Rage, the musical, for example, again. We're not talking Taylor Swift's name. We're not talking Swifties. We're not talking reputation or, bad blood. And we're not talking blank space or this is why we can't have nice things. Like all of the marks that we just immediately associate with Taylor Swift. I mean, Female Rage, the musical, like that third parties could go crazy with that and move forward with that. I don't know if she's going to get that trademark registration, but she filed it and her legal team thinks that she has a good chance of doing it. So she's expanding other goods, other service offerings. And this is called international classes through the United States Patent and Trademark Office. So the Trademark Office as a whole, when you're filing a trademark application, you have to file in goods classes and or service classes, and you can file in multiple classes for the same mark that you're trying to register. But when you go beyond the scope of your original, say, trademark that you have, then you have to file it again in other classes. International classes is what they're called. So just think about that. Like, what are the expansive goods and services that you will be offering now and into the future? And then last, I want you to carefully review any agreements that you have dealing with ownership of IP to ensure that all of your workers or any third parties or other businesses that you work with don't own any IP rights, which could be used without permission of you as the creator of the IP, or if you're like in a work for hire situation, contractor situation, who owns that IP when they're working for you and creating things for you. So just check on all of those things. And I want you to be the mastermind of your own IP strategy as well. Now, let's quickly go over filing a federal trademark through the trademark office. There are several steps involved here. So what I want to do is really just give you a detailed guide from my mouth to your ears on how to go about federal trademark registration. I also have a step-by-step guide for you that I will link in the episode description if you would rather kind of have a checkmark approach to filing a federal trademark registration through the USPTO. And I have lots of pictures in that guide as well. So let's just quickly go through these steps. First, determine the eligibility of your trademark. So you can't move forward in the trademark process if your trademark isn't unique and distinguishable from others. So trademarks can be words, phrases, symbols designed, or a combination thereof that identifies and distinguishes your goods or services under your brand. If you feel like you have a really unique brand name, sub-brand name, symbol, design. Of course, you can do logos. Think here like the Starbucks logo. We all know that very well. The M arch with McDonald's, the Nike swoosh. Those are symbols or designs, but of course, words and phrases. So the Legal Paige, mine is just a word mark, the Legal Paige altogether, so that I can use it in various formats. Then I want you to conduct a trademark search. This can be a little bit tricky. It's through the Trademark Electronic Search System online, TESS. All of us know this as intellectual property attorneys. You have to go to the USPTO's website and you have to check and see if your trademark is already registered or if there are similar marks. I like to also do this state-based as well, but if you're trying to file for a federal trademark, which is what most of you will be doing because of interstate commerce and you have clients and customers from various locations throughout the US, this is really important for you to decide whether or not it's taken or there are similar marks that may be taken to avoid potential conflicts, rejections from examining attorneys that are looking at your trademark application. And then that just increases the cost, increases the time, increases, honestly, all of the turmoil involved in a potential trademark application. Next, you want to choose the correct application form. So with the USPTO, there are two forms, the TEAS Plus and the TEAS Standard. So the Plus requires more detailed information up front. It does have a lower filing fee, and this one's really great because they have kind of stock descriptions for you to choose from. So if you're in maybe international class 9, like more downloadable software, and they can offer you just pre-done descriptions and at a lower filing fee so that the USPTO already knows that those are agreed upon descriptions under IC9. And that's why it's a lower fee. But then the standard offers a lot more flexibility in providing descriptions to each mark under each international class. It comes with a higher fee, but a lot of intellectual property attorneys choose to go this route as a more custom approach. Next, you'll prepare your trademark application. All of this is done online, and the USPTO website has a lot of good guides and step-by-steps as well. I also will give you my guide in, PDF format for you to walk through. But the application online and through the USPTO system, it's a little archaic. No, it's a government website. So you have to do a lot of different things like the owner information. You have to provide the name and address of the trademark owner, whether it's the LLC that's owning it, whether it's you owning it individually, whether there's joint owners, all of that information. Then mark information. So you have to display the mark, whether that's, a symbol, a design, or it's just a word mark. Then you have to choose the goods and services. So you have to specify, is this a goods mark? Is it a service mark? And then you have to use their acceptable identification of goods and services manual for guidance. You can file the basis for filing. So is it used in commerce already? If you're already using the trademark in commerce, or is it an intent to use application if you plan to use the trademark in commerce in the future? Then you have to make a description that is suitable for the application under each of the international classes that you want to file in. This is where things get a little bit complicated, and this particular portion of the online form can get really cumbersome and long. The more classes that you add on, obviously there's a fee attached to each class as well. So you have to think about budget here. Then you also have to submit a specimen for each of the classes If you are using this mark in commerce already, then you would submit a specimen, an intent to use. You would submit a statement of use once you get a notice of allowance through the USPTO. I'm getting a little bit ahead of myself here, but if it's used in commerce, then you have to submit proof that you are using it in commerce. And that's what a specimen is. So it's an example kind of showing that the trademark is in use for the goods and services that you are intending to apply for. And a lot of times this is like screenshots online, website screenshots with dates, advertisements, any type of labels, if you have logos. Sometimes you can do social media posts and the like. Then you have to pay a filing fee. So once you go through the application, you pay the filing fee at the very end, and then you file the application. So once you submit the application, then it's just in like waiting mode. And the USPTO will have an examining attorney assigned to your application. They'll review your application. And you just have to monitor it at that point. You're hoping that it comes back unscathed, that your application, soars through the process. That's going to be 6 to 12 months out until an examining attorney is even going to look at your trademark application. But again, the most important date here is the date that you file that application. That's why it's so important to do it as quickly as possible. Also, because it takes a really long time to get a trademark, but it doesn't matter when you get the actual registration. It's when you submitted and when you were first in use. So you got to monitor the application. Usually you'll get a notice from the USPTO that there's either a non-final office action, and it'll detail like issues that need to be addressed. You have to respond promptly and appropriately, usually within 3 months. And then if you do respond and they decide to move forward and grant you registration, sometimes they don't. Sometimes it's like a final office action. And that's when you have to hire an attorney if you're doing this yourself, because you don't know how to accurately respond and you've already spent, hundreds, if not thousands of dollars trying to file this application. Then if they do move your application through the process and the USPTO approves it, you will be published in what's called the Official Gazette. And this gives others a chance to oppose your trademark registration. I have been in litigation before and am still in litigation as an IP attorney for our clients during that opposition phase. So a lot of times you'll see someone else try to file a trademark or squat on a trademark for a trademark that you actually have first usage of way back when. Then you would oppose that trademark because you don't want them to own your trademark and then have issues with licensing and them trying to like sell the trademark or send cease and desist and for them to like take down your use of the mark. If no one opposes, then you basically get the application resolved in your favor and the USPTO will give you a registration certificate. So for intent to use applications, if it's not like in use already, at this point, you would need to file that statement of use, or you just continue with extension requests before trademarks are registered. I have had intent to use applications with my clients through my law firm for many years. And sometimes they have manufacturer issues or things along those lines where it delays the process. But you can file, I think, up to 5 extension requests, maybe 6. Don't quote me on that. I'll have to go look. And so you have sometimes like you want to file the trademark. You don't want anyone else to use the trademark. It's published for opposition. You get the notice of allowance, and now then the clock starts. You probably have about 2.5, 3 years to get your statement of use in maximum. You do have to pay a fee for all of those extensions. But I'm just trying to give you a little bit of a timeline here. If you're like, I think I may use this into the future. And then you have to maintain your trademark. So it's all about making sure that no one else uses your trademark, no dilution occurs. That's what Taylor Swift's legal team does all the time is they send cease and desist. They're trying to take down infringement related to any of the marks that she owns. This is where also intellectual property attorneys come into play because it's really, really hard to know how to maintain your trademark, to send cease and desist constantly. We have programs and applications that help monitor this for our clients. And then we also do sweeps. And then we obviously help prepare C&Ds for our clients as well. And then you also have to file maintenance documents and fees to keep your trademark active. So it's not like you own the trademark forever and ever. there are things that are called Section 8 declarations of use and Section 9 renewal applications. And those are at specific intervals. And it's really just, okay, 5 to 8 years out, are you still using this mark, or should we allow it to go to other people? So you just have to be like, yep, it's still active. I'm still using it. And that's a Section 8 declaration. An important thing to note here, as I'm talking through all of this, is you're probably like, Paige, this is a lot. Yeah. I do this every day through my law firm, and navigating trademark registration is complex, it's cumbersome, it's confusing. Like I said, the USPTO website is archaic. Also, just knowing what you need to do and doing it properly so that you have as little of issues as possible that could potentially come up, making sure that you're not using descriptive marks, making sure that you're not using similar likeliness of confusion going on with other marks. I want you to consult with an IP lawyer. Trademark attorneys they truly can help you so much, and make sure that the application is properly filed. They also do, and I do, what's called trademark clearance letters. So before we even go through the process, you come to me, you say, hey, this is a mark that I'm really interested in. I will do a sweep and I will write a clearance letter for you. I do all of my back end work. We have applications that do this. I do my own custom search approach. And then I give you a detailed legal explanation as to, yes, I think that you should move forward with this trademark application. Here are some potential issues that come up, but I think that they will be resolved easily. And this is kind of what I would forecast. Be prepared for XYZ, but let's do this. I think this is going to be amazing for your brand protection. Or I'll say, this isn't a good idea. Let's stop here. Don't spend any more money. Like, I'm going to tell you straight up what the best approach is. And all IP attorneys should do this as well if you're working with any other trademark attorney. Ultimately, I just want you to understand the process. I want you to understand why trademark protection is important, how it is one of the most valuable intangible assets that you have for your business. You can sell your business at a higher monetary value when you own trademarks and have that goodwill associated with your brand. And the more time that goodwill is associated with your brand, the higher the monetary value is. Of course, you prevent other people from taking your brand name or logo or symbol or tagline and using it for their own financial benefit and commercial gain. That's huge. That's why we all create unique brand names to begin with and logos, so that it's yours and only yours, and everything associated with that brand and every marketing and advertising effort you put into your brand is only associated with your brand. And then, of course, it's really good practice to protect your IP and to make sure that others aren't infringing on your IP as well. And then you can also license your trademark. So one of the things that I know a big brand does here in Montana, so the University of Montana Grizzlies, I went to this entire CLE on the trademark ownership of Grizz and Grizzlies and all of the trademarks that they own. They license and make so much money licensing their trademarks. And they make sure that they are monitoring and protecting infringers that haven't properly licensed their marks. But I mean, we're talking hundreds of thousands, if not millions of dollars in licensing fees, so that other people and, small businesses here in Montana, like if I go to a trade show or, like a little art bazaar and there's, Grizz coasters or Grizz mugs, they have gotten proper licensing from the university to be able to do that. So I don't know if you know anything about, university trademark ownership licensing. It is one of the biggest businesses in the United States. I digress, but licensing is really important as well. So say I were to own some tagline of my business and other lawyers or virtual lawyers wanted to use that tagline, I could license it for a fee and make money, but they could still use that tagline. That's a good example. Okay, so hopefully you gleaned a lot from the Swift effect and what you as a brand can learn from Taylor Swift. Call it what you want. I want you to have a big reputation. Wink, wink. And if you need assistance with your brand protection or you would like advice about maybe your intellectual property and trademark strategy, please, please, please just message me and contact a member of my legal team at Griffith Law, which is my law firm. I like to call this a sister business to the Legal Paige. So TLP is truly an online legal education platform and contract shop. It is not a law firm. And my law firm, Griffith Law, can help you one-on-one with any of your business needs, including trademark registration and copyright registration. So if you are looking to secure a mark or a brand name, logo, symbol, sub-brand name, little tagline without issue and hiccups, and with the utmost professionalism and legal skill, I would love to help you out, as would my legal team. We are trademark experts, intellectual property experts. Like I said, we do clearance letters for you. We will handhold you through the entire process and do it for you because, yes, you want to own it, and that's important for your business and your brand, but you don't have time to do this. I know you might want to save a little bit of money, but I can promise you, you're not going to save as much as you think, and you're certainly not going to save your time and energy that you could devote to your business and make all that money back plus some. So please, please, please contact me if you are interested after listening to this episode at all. I will link to Griffith Law in the episode description for you. I am also very excited to be partnering with one of my longtime associate attorneys at the Legal Paige, and she will be joining the law firm as a partner. And so her and I have tons of experience in this industry. We would love to assist you. And yeah, please mention once you contact us that you listen to this episode, because we have a special exclusive discount just for you if we do help you pursue trademark registration through our law firm. So thank you so much for tuning in, for listening in. I hope you gleaned a little bit about, why Taylor Swift has taught us so much about getting your brand name out there and protected. And I want you to do the exact same. We may not be as big of a brand as Miss T Swift herself. Hopefully you've gone to the Eras Tour and seen how amazing this brand actually is on stage and off stage, with all of the swag and all of the materials and just everything that she pours into building her art and artistry and business as a whole. But I want you to do the exact same thing and protect your brand in all of these trademarking lessons that we've learned today. So that's all. I cannot wait to hopefully have a bigger conversation with you about your intellectual property protection. And I will catch you in the next episode. Thank you so much for tuning in to today's show. Be sure to visit thelegalpaige.com for contract templates, blogs, YouTube videos, and additional legal resources. If you haven't already, head over to iTunes and leave me a review and rating. It truly means so much to me to hear your feedback and inspires me to continue creating podcast content. Also, I want to personally invite you to my free Facebook group at tlpfacebook.com, where you will get access to me, my legal team, and thousands of other entrepreneurs in there for unlimited business and legal Q&A. Until next time, my friend.